This presentation is part of a series of presentations on compliance tips for operators. This is based on over 30 years of public inquiry representation experience. In this presentation, we identify key considerations for haulage operators in connection with vehicle inspections, maintenance and record keeping. We refer to these inspections as preventative maintenance inspections, or PMIs for short. This slide shows the first page of an example PMI sheet, followed by the last two pages. The mechanic should be using this sheet as a contemporaneous checklist as he carries out his vehicle safety inspection. We find a lot of mechanics will fill the sheet in after they've completed the inspection, which isn't advisable, as there is then a temptation to fix defects on the fly rather than just list them down. The safety inspection should be conducted in the same way as an MOT inspection, identifying any defects, and then, having identified the defects, the mechanic should then proceed to rectify those defects. Operators should adhere to the interval frequency stated in their application. This is a statement of intent that needs to be adhered to. The frequency can be shortened or lengthened, but any change to the original statement of intent needs to be notified to the Office of the Traffic Commissioner. The detection of safety-related defects that would attract an immediate or delayed prohibition at PMIs may indicate the PMI interval needs to be shortened. An absence of such defects might indicate the interval should be increased. Vehicles can be inspected at any time within the ISO week that the PMI is due. Vehicles over the age of 12 years should never exceed a 6-weekly interval cycle. If the PMI is undertaken externally, then when the vehicle is collected, the PMI sheet needs to be available for inspection by the driver, who should then conduct his walk-around check before the vehicle is operated. The driver should check the PMI has been completed and that all defects have been received and the declaration of roadworthiness has been signed and dated. The PMI should subsequently be handed in to the transport manager or other competent person employed by the operator for their own inspection prior to filing away. If a brake test has been conducted, then the brake test results should be analysed in accordance with guidance contained in the FTA Brake Testing Guide that is freely downloadable from the FTA or Logistics UK website, or if you can't find it, email us and we'll send you a copy. We advise you to keep a record or register of PMI checks when you undertake them. You should check the vehicle was inspected on time. You should check that all defects have been signed off as rectified. Where appropriate brake testing has taken place, ideally using a laden rolling road brake test with a printout for analysis, you should check that analysis. Driver detectable faults on the PMI should be cross-referenced with the relevant driver defect sheet, and an investigation needs to take place if it becomes evident drivers have missed defects they should have picked up on. You should check the vehicle roadworthiness declaration is signed off. Vehicles should not be allowed to be operated on the road unless the signature is present. This should have already been checked by the driver at the point of collection of the vehicle, and if the declaration has not been signed, then this needs to be addressed not only with the maintenance provider, but with the driver as well. You need to be monitoring your maintenance provider's ability and effectiveness in maintaining your vehicles in a roadworthy condition. This can be done by monitoring your MOT pass rate on first presentation. Every fail or PRS needs to be investigated and action taken to address the reasons why a fail or a PRS was recorded. The national average for a first-time pass is around 90%, and operators should be looking to exceed this. If you get a prohibition, investigate it. Was it something your maintenance provider failed to pick up on inspection? For example, was there evidence of rust around the studs to indicate the loosening of a wheel nut had occurred over time, possibly prior to the previous PMI? Again, is this something that should have been reported by the driver when doing his daily checks? Is the maintenance provider completing the PMI records correctly? Is the maintenance provider achieving adequate standards? But if not, and despite your interventions, the situation is not improving, then you must look to change maintenance provider. This slide considers problems posed by third-party trailers. This is something that is frequently overlooked, but it is hugely important. Ensuring third-party trailer roadworthiness can, of course, be problematic for those undertaking the haulage. When a trailer is coupled to a tractor, that trailer is being used by the vehicle operator. What checks have been undertaken to ensure the trailer has been PMI'd by its owner? Ordinarily, the trailer owner would be responsible for the routine maintenance of the trailer, including the PMI, but the liability rests with the haulier operator in the event the trailer has a defect. Drivers obviously need to carry out daily checks that include the trailer as well. Under these circumstances, the haulier operator is going to be reliant on the trailer owner carrying out the PMIs, the frequency of which needs to actually mirror the stated frequency set out in the haulier operator's statement of intent, and the two may be entirely different. Haulier operators are expected to work with the trailer owners to ensure any trailers operated by them fall within their declared PMI frequency for trailers and that they are maintained in a roadworthy condition. Haulier operators should seek to obtain a copy of the most recent PMI for the trailer and ensure that the trailer has been PMI'd within the relevant interval. Monitoring. Traffic commissioners have made it quite clear that directors of haulage companies cannot simply rely on what their transport manager tells them. The directors have a duty to check and verify that the obligations under their operator license are being complied with. Directors need to proactively check PMIs and driver defect reports, or at least a random sample of those, every so often. And they need to do this to satisfy themselves that everything is in order. This type of audit should take place on a monthly basis and could effectively be undertaken during a regular planned meeting with the transport manager. Additionally, operators are recommended to seek an external compliance audit by a consultant from time to time. We recommend this be done and such an audit be undertaken on an annual basis. This will ensure the maintenance regime is effective and compliant. Where an operator is called to a public inquiry, quite often the traffic commissioner will ask that operator to give an undertaking, and often that undertaking relates to having an external third-party audit conducted on an annual basis. Sometimes an operator will say to us, well, we've done a couple of these now, can we apply to discharge that undertaking? And the answer to that is, well, yes, you can. But should you? These external audits are important because they do impose a discipline upon the operator to ensure things are done right. And perhaps the best way to ensure your operation is compliant is to have someone from outside looking at the operation and scoring it. And that is essentially what an external audit is. Therefore, we would always recommend, irrespective of what the traffic commissioner requires, you do have these external audits. They're worth their weight in gold. We hope you found this presentation of use, and we look forward to presenting you with other tips for compliance in due course.